Hello, everyone. Welcome to today's seminar hosted by AICG, the Asian Institute of Corporate Governance at Korea University Business School. My name is Junho Hwang, Professor of Finance at Korea University Business School, and I am honored to serve as the moderator for today's session. Today, we will explore the mandatory bid rule, which is a regulatory concept for protecting shareholder rights during takeovers, and discuss its potential implications for Korea. Through insights gained from the European experience, we'll examine how different approaches to this rule impact both acquirers and minority shareholders. We hope this seminar will provide a comparative perspective and offer valuable lessons that help Korea design and implement this regulation. We're fortunate to have with us an esteemed speaker and panelist who will provide valuable insights on this topic. So at this time, I'd like to introduce our keynote speaker, Professor Rolf Skog. Mr. Skog is the Director General of the Swedish Securities Council and an honorary professor of company law at the University of Gothenburg. He has served as an expert to the Swedish Ministry of Justice in company law and takeover regulation, and was a key figure in the development of the Swedish Company Act of 2005. Additionally, Mr. Skog has been a member of the European Corporate Governance Forum, appointed by the European Commission, and has published extensively in the fields of company law, corporate governance, and stock market regulation. With that said, please join me in welcoming Mr. Rolf Skog for his keynote address.
Well, thank you so much. Thank you for inviting me. And I look forward to this seminar to share with you some experiences from this Swedish takeover panel, which is also the Securities Council in Sweden. And I think we could start right away. I will take you through the Swedish regulation, do some reflections, and then we will have time for a discussion in the panel. So if you could please turn to the next slide, which is... yes, thank you. Next, please. Yeah, a little bit of background before we go into the mandatory bid rule about the Swedish stock market. The Swedish industry, to start with, we have, as you very well know, I think, quite a few very large international companies in Sweden. And most of the large Swedish companies are listed. That you recognize names like Ericsson, SKF, Volvo, HM, and others. In total, there are approximately 1,000 listed companies in Sweden today, which makes Sweden the largest stock market in terms of numbers in Europe, except for the UK, of course. But if you look at the European Union, Sweden has the most listed companies of all the member states today, 1,000. Germany has roughly 800, France 600 something. And there are three marketplaces. Nasdaq Stockholm is by far the largest. We have another one called the NGM, and then we have Spotlights, with three altogether. In terms of market value, to say Sweden is number 3 or number 4 when it comes to the total stock market value in Europe. Next, please. The structure of ownership is, of course, of interest when you discuss mandatory bid rules. Sweden or Swedish listed companies are characterized by quite a concentrated structure of ownership, typically. If you pick up randomly an individual company, you will most likely find a controlling owner or controlling group of owners holding somewhere in between, I would say, 20 to 40% of the votes in the company. In some cases, based on the holding of high vote shares. We allow in Sweden multiple vote shares with a maximum ratio of votes 1 to 10. There is also a high degree of institutional ownership of the total stock market value. Roughly 85% is attributable to institutional shareholders like pension funds and mutual funds, etc. Also, a large international or foreign ownership. Roughly 40% of the total stock market value is attributable to foreign owners, which is basically foreign institutional owners. Swedish institutional owners, lastly, are quite active. They typically participate in nominating committees in all listed companies. They are active in the debate about Swedish corporate governance, and nota bene, they are also very active when it comes to regulation of the Swedish stock market. So they do participate in different fora where laws and rules are created, so to say. Next, please. So takeover activity then. Well, takeovers are common, and they have been common for a long period of time in Sweden. There are approximately, on the average, 20 to 30 bids per year. This year is almost a record year. We have already almost 40 bids this year. Most bids are recommended, and we can leave out the last one on the real mandatory bids. I'll come back to that later. But most bids are recommended. So if you compare the takeover activity in Sweden to, for example, London, you will see that if you take into account the total number of listed companies, which is roughly twice as many in London, the level of takeover activity is roughly the same in Sweden as in London, and has always been. The takeovers have been common in Sweden for 3-4 decades now. Next, please. So the Swedish Takeover Panel, or the Securities Council, which is the kind of official name of it, was established in 1986. And this was established as a pure self-regulatory body, just like the London Panel. And the London Panel and the London City Code on Takeovers and Mergers served pretty much as a role model for the Swedish system when it was set up. Due to the EU directive on takeovers, however, as of 2006, we are acting on behalf of the Financial Supervisory Authority and the stock exchanges. So the Financial Supervisory Authority is the designated supervisory authority in accordance with the EU regulation. But the lawmaker and the FSA has delegated the power to exercise these the oversight and also the interpretive rulings and the ad hoc exemptions to the takeover panel. The panel is quite active. We give roughly 60 to 70 rulings or statements per year. Just yesterday, we issued number 70 this year, and they are all issued in written. Unlike the London panel, all decisions, all statements, so to say, are in written, and they are, most of them, readable on the website. Some of them we do not publish immediately due to the fact that they are related to planned transactions, so to say. Most of the issues or questions that or applications that we receive are given to us on before a transaction is done or published. Yes, thank you. So let's move to the mandatory bid rule, and you very well know the basic idea here: to protect shareholders, as was mentioned already in the introduction here, upon a change in control of a listed company. Well, could be unlisted as well, but in Sweden, as in most other countries, the mandatory bid rule applies to a situation in a listed company. So a party which acquires shares in a company to such an extent that control is achieved must offer also to acquire the remaining shares at a price determined in a certain way in the regulation or the rules. And this is what we are now to explore, how this is carried out in the Swedish regulation here. So let's turn to the next one and see, we have a number of issues to go through here. First, we will explore the trigger event. What triggers the mandatory bid rule? We will have to look into the acting in concert concept, which applies here. We will take a closer look at the bid, the timing of the bid, the price, the conditions, etc. We have to look into exemptions, including what is termed whitewash procedures, a little bit on sanctions, and then last but not least, the very important question of grandfathering, which comes into place when you discuss the introduction of a mandatory bid regime. So next, please, the trigger event. And let me say from the very beginning that the mandatory bid rule in Sweden was introduced in 1999. So when we started out with the takeover regulation in 1986, there was no mandatory bid regime there. We didn't pick up that specific element from the UK. And as you might know, the UK system was put in place in 1968, and they didn't have a mandatory bid rule from the very beginning. They introduced it in 1972. Anyway, this is the rule, the most important one. This is where it starts, and I've cited the Swedish regulation, and we can look at it and then go through the different details. A party who holds no shares at all, or holds shares representing less than 30% of the voting rights for all shares in a listed company, and who, through acquisition of shares, alone or together with another closely related party, that's the acting in concert, reaches a shareholding representing at least 30% of the voting rights for all shares in the company, shall make a bid. We'll come back to that. Now, you know the saying, the devil is in the details, and this is certainly true when you look at this. We have to go through the different details here and take a closer look at them. And let's start with the acquisition. So let's turn to the next slide and take a closer look at what is meant with acquisition. And there are a number of reflections here. First of all, the manner of acquisition is irrelevant. It may be a plain purchase, but can also be, for example, a subscription of shares that issued by the company, or a conversion of a convertible debt instrument, or an inheritance, or something similar to that. So the way you acquire the shares is of no relevance. The number of shares you acquire is not relevant either, as long as you, as the acquirer, reaches 30% or more of the votes in the company. You could very well reach 80%. Still, you have to make a mandatory bid as soon as you are at 30 or more, so to say. What about other instruments? What about if you acquire warrants or convertibles? No. That's not relevant. Only holding of shares are relevant. And neither do we take into account contracts for differences or similar arrangements, contractual. It's only holdings of shares. And the idea here is that the mandatory bid is triggered when you are able to exercise voting rights representing at least 30% of the votes in the company. Hence, from this follows also the last point here, that the acquisition must be definitive. It might not, if it's contingent on certain conditions, well, then you have to wait and see if these conditions are fulfilled. Otherwise, the bid is, or the mandatory bid regime is not triggered. Next, please. What about the 30% Then how do you calculate that? Well, also a number of questions arise here. First of all, when calculating the total number of votes in the company, well, then sooner or later you will run into the question, what about treasury shares held by the company? The company buys back shares every now and then. How do we take them into account when we think about the denominator here? Yes, we do. The company's buyback of its own shares has, as I state here on the slide, no impact on the number of shares any outside party may acquire without triggering the mandatory bid rule. It would, to put it simply, be just too complicated for a shareholder to keep track on the exact number of shares at each and every time in the company when the company do buyback or exercise buyback rights. So buybacks are of no relevance when looking at the denominator. What about convertible instruments or subscription warrants issued by the company? No, again, they are not included, or they are not included, I would say. Again, with thinking about the total numbers of votes out there for shares issued by the company. Next, please. So here comes then the acting in concert, and this is as you very well know, I think, quite a difficult topic. How do we look upon parties potentially acting in concert to take control, or that might result in control of the company? Well, there are easy cases, of course. A closely related party shall be deemed to be the spouse or a child, a minor child. That's natural, but very, very uncommon situation, so to say. A company in the same group, well, of course, a subsidiary or a parent company is supposed to be acting in concert, or presumed to be acting in concert with another company in the group. That's easy to understand. Most important, though, is the third one here, which is carefully drafted to kind of fit into the Swedish corporate governance system. This says, while a closely related party shall be deemed to be a party with whom an agreement has been reached to take a long-term common position with the purpose of achieving a controlling influence over the management of the company through a coordinated exercise of voting rights. This one has to read carefully. Think about two or a group of institutional investors in Sweden, and they, before an annual general meeting, they come together and they agree upon what they think should be the composition of at least the majority of the board. Would that trigger, would they be considered to be acting in concert? Well, if that would have been the case in Sweden, it would certainly affect the Swedish system with nominating committees composed by large institutional investors or large shareholders. Hence, this specific para is interpreted when it says to take a long-term common position. It is meant to be understood as taking a common position for more than one mandate period. Hence, typically for more than 1 year, since the mandate period for board members in Sweden is, according to the law, 1 year, if nothing else is stated in the bylaws. So, and that's the most important one. Then we have a final point here, a party who cooperates with the acquiring party for the purpose of achieving control of the company. Well, of course, that can happen. But that the precondition for this last one is that there is a buyer trying to take control, and he has one or two or three parties helping him to acquire control of that company, maybe paving the way by buying shares in the market or in another way, helping this party to acquire control or achieving control. We very, very rarely make use of that, I can tell you. Okay, next one, please. What about other events than just acquiring shares then? Could they trigger the mandatory bid rule as well? Well, the mandatory bid rule is triggered, stated on this slide, if certain acting in concert situations are established. And the very typical one is this: two shareholders, A and B, they come together, they hold each of them 50% or more. They enter into an agreement regarding coordinated exercise of the voting rights for this long-term period to come. That triggers the mandatory bid rule because a new 30% controlling constellation is created. And then this one can discuss. There are jurisdictions in Europe and elsewhere where this would not trigger a mandatory bid rule. This would not be considered to be equivalent to the acquisition of shares of 30%. But in Sweden, this is the case. Next, please. But there are also events related to acting in concert or that do not trigger the mandatory bid rule. Such an event, which is not uncommon, is that there are certain measures taken by the company. For example, the redemption or cancellation of shares. You can very well think about a shareholder holding 29%, and the company decides to redeem a certain number of shares, resulting in this specific shareholder reaching 30% or more suddenly. The mandatory bid rule is not, according to Swedish rules, triggered in such a situation immediately. However, if this specific shareholder later on acquires one or more additional shares, well, then the mandatory bid rule is triggered. So I guess one could say that the mandatory bid is kind of latent in this situation. Well, you're allowed to stay at 33% or whatever, but as soon as you buy one more share, the mandatory bid rule is triggered, or the mandatory bid is triggered. Yes, thank you. Next one, please. This is an extremely important one, the bid and the conditions for the bid. We already read the first part of it. A party who holds blah, 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 and reaches 30% has to make what? Well, has to immediately make public the extent of his shareholding in the company. So the market has to know immediately. Now, shareholder A has reached 33%, for example. That's an immediate message to the market to be sent. Then this specific shareholder has 4 weeks to consider whether to launch a bid in respect of the remaining shares or step down, and we'll come back to that. So it's a 4-week period before you have to make the mandatory bid rule. Next, please. So this shareholder has the possibility to step down, to decrease his or her shareholding within this 4-week period. And there might be different ways to do it, but typically it's just to sell a certain number of the shares. During this period, during the 4-week period, No matter if you're intending to make a mandatory bid rule or you're intending to sell down or step down, you may not exercise voting rights representing more or 30% or more of the total number of votes in the company. So it's a kind of, well, not a standstill, but you should not be able to buy the shares and start exercising 33% during this 4-week period before you make the mandatory bid rule. Not mandatory bid, sorry. Okay, next one, please. When it comes to the conditions in the bid, it's I typically describe it, and this is also the way it's drafted in the rules, that the rules relating to voluntary offers applies to mandatory offers as well. One could think of the mandatory bid regime as just a regime telling demanding when you have to make a bid. And then the starting point is, well, you have to make a bid then in accordance with the rules for the voluntary bids. However, there are, of course, certain differences here. First of all, the mandatory bid rule must always apply to all of the shares in the target company. You may not make a partial mandatory bid. I mean, the idea is, again, to protect the remaining shareholders in the company. Second, the offeror must always offer all shareholders the option to receive cash in the bid. There might be alternatives. You might offer also, for example, shares in the offeror, but there must always be a cash alternative. Cash is king in these cases, so to say. When it comes to the conditions, the offeror may make the offer conditional only upon official authorizations or regulatory clearances being obtained. You may not, of course not, I would say, have, for example, an acceptance condition saying, well, this bid is conditioned upon the bid reaching 90% or something like that. That would do away with the kind of minority protection aspect of the mandatory bid rule. So no other conditions than official authorizations or regulatory clearances, typically from the competition authorities, and nowadays also maybe from the screening system for foreign investments. The acceptance period, well, basically that's the same. The rules are the same as for voluntary bids. The only difference here that in a mandatory bid situation, the offeror may not extend the acceptance period or may only do it if it doesn't delay payment of consideration to those who have already accepted the bid. Next, please. Now we come to the bid price. And this is, of course, of utmost importance. The rule says the bid price may not be lower than the highest price in any acquisition of shares in the target company by the offeror or a closely related party during 6 months prior to the mandatory bid. And the same applies during the offer period and also 6 months after. But the most interesting part here is, of course, the pre-acquisition. And you should carefully note that this rule applies also to voluntary bids. It's exactly the same rule. If you make a voluntary bid today, you have to take a look at what acquisitions you have made or a closely related party to you has made during the prior 6 months period. And the bid price may not, in a voluntary or in a mandatory bid, be lower than the highest price you paid for any share in the target company during this 6 months period. So, and the rationale stated here is equal treatment of the target company shareholders, and you can look upon it as you extend the equal, since you may not offer different prices for shares in an offer. Well, you may not then, or you extend this equal treatment principle also 6 months back and 6 months ahead. So you have an equal treatment period running from 6 months before the bid, during the bid period, and after the bid for 6 months. Next, please. There might be cases when there is no relevant prior acquisition. That happens. Think, for example, about an investor holding 29%, subscribing to new shares in the company issued by the company. Well, then the price for subscribing to the shares is no relevant. There is no equal treatment problem there, so to say. And another case might be you convert a convertible debt instrument into shares. There is no relevant price prior to the acquisition here, so to say. Then we have this fallback rule stating, well, then the bid price in the mandatory bid, as well as in a voluntary bid, may not be lower than the volume-weighted average price during 20 trading days preceding the date of reaching 30%. That's just a kind of fallback rule, so to say. Next, please. Now to exemptions. And there are different philosophies on how to deal with exemptions, or how to regulate, if I may say so, exemptions when it comes to mandatory bid regimes. You could think of a system where all exemptions are in the takeover regulation already. You could also think of a system where there are almost no exemptions in, or maybe none, in the regulation itself, and all exemptions are given ad hoc by the relevant supervisory authority, which might be the takeover panel. Sweden is pretty much in the last vein here. There are almost no exemption in the Takeovers Act, while that it's in the hands of the takeover panel to decide upon exemptions case by case, depending on the circumstances. And let's look at the circumstances that might be relevant here. Well, in the rule, there is only one in the takeover regulation, one exemption, and this is the one. The mandatory bid rule is not triggered where a party reaches 30% of the voting rights through a public offer for all shares in the company. Hence, if I start out from zero and I make a bid for all the shares in the company and I reach 33%, well, then I don't have to make another mandatory bid rule later on. I can stop at 33%, and if I want, I can later on buy more shares on the market or during a negotiated transaction. Well, this, of course, opens up for the what is these days called lowballing. Suppose I hold 29%, for example, and at a specific time and during specific market conditions, so to say, I decide to make a bid for the rest of the shares, and I know that, well, the market is down, and I could at this moment offer a very, very low price for the shares, and hopefully quite a few shareholders will accept this bid. They don't know better, so to say, and I will reach 32 or 33%, whatever. I'm above, but that's it. Then I have kind of paved the way for later acquisitions. That is the case in Sweden. You could do it. We see very little of this. During the last year, and maybe 2003, we have had a few cases where you can probably say, well, it looks like what is called lowballing. There are no specific rules on it. And we have actually tested a couple of years ago in a group that kind of drafts proposals for revisions of the code. We have tested the idea of introducing the UK rule that you may not, that the offeror may not declare the bid successful, so to say, if you don't reach at least 50%. I think that would be a good rule, but so far we have seen very little interest for such a rule in Sweden. We might come back to it, and we can discuss it in the panel discussion later on. So next, please. When it comes to ad hoc exemptions, well, first of all, you have to understand that this requires a special cause. Special causes must exist. Otherwise, there will be no exemption, so to say, from the panel or dispensation, whatever you would like to call it. If we look at the most typical cases that we deal with, first, I would say preemptive right issues. Suppose I have 29%. The company issues new shares on a preemptive right basis. I subscribe to my portion of the share, my portion of the newly issued shares. All shareholders are not interested, and hence I run the risk of increasing my relative position in the company. Let's say I end up at 32% then. That would immediately be a cause for an exemption from the panel. So we would exempt this specific shareholder based on the fact that she has just exercised her preemptive rights in this issuance of shares. Another very common situation is that a listed company purchases another company or some kind of property, maybe real estate or whatever, and the seller of this property is paid in shares of the listed company. Hence, me as a seller of this property or company, I become a possibly large shareholder in the listed company holding above 30%. Well, that would trigger a mandatory bid for me, but this is yet another case where you can rely on getting an ad hoc exemption by the panel. However, we would in such a case demand a whitewash procedure, which means that the general meeting of the listed company must accept or clear this situation by a majority vote, qualified majority vote of the non-conflicted shareholders. So if I'm already a shareholder in the listed company on beforehand, I may not participate in the vote or the decision making of the shareholder meeting. That's also quite a common situation. Could also be a kind of reorganization, a different kind of reorganization in a listed company that is in dire economic straits. That would also require a whitewash procedure. Suppose, for example, that the company needs to make a targeted share issuance to a specific investor. Could be me accepting to become a large shareholder, 40%. Well, if the remaining shareholders accept this, I do not have to make a mandatory bid. Could be a situation where I reach more than 30%, but de facto there is no change in control. Take, for example, the situation if I reach 33% in one way or another by acquiring shares, for example, but there is also already a larger shareholder in this company holding 40%, well, it would be meaningless saying, well, Rolf has then, he is in a control position. Well, if someone holds more than me, this might be considered as being a non-de facto change in control. Could be other cases as well, but we'll leave them out. And 2-3 slides left. Next one, please. Sometimes you wonder and you notice differences among jurisdictions when it comes to what is exactly the meaning of an exemption. Well, a couple of questions arise at least. Suppose shareholder A is given an exemption to hold 40%. Then one question is, can A later increase the holding? I'm giving this dispensation. I participated in a preemptive right issue. I reached 40%. I was given a dispensation or an exemption by the panel. The answer is no. You are given this, or you receive this exemption based on the specific circumstances at the moment you reach this position. That doesn't give you the right to increase your holding. You can sell down to 35% or 30%. Yes, of course. But can you, if you sell down to 35%, could you later increase to 40% again? No, you cannot. Again, you must remember the specific circumstances that was the ground for giving you a dispensation. And that is not relevant when you think about increasing again from 35 to 40. Next, please. No rule, just exemptions. That's a question one sometimes can ask, especially if you look at the situation in Sweden, for example. We give a lot of dispensations, I would say, or exemptions. My guess is that this year, out of 70 statements, maybe 30, 40 of them are exemptions from mandatory bids. Does that mean we always approve? No, that's wrong. The thing is that since we have had this system now for 25 years, the legal advisors, and it's always legal advisors involved here, the very large law firms, they know exactly the preconditions for receiving an ad hoc exemption, and most applications are then approved. They know exactly when to come to us. But it happens that we turn it down and say, no, this is not enough. You have to do it in a different way. Sometimes they come back, sometimes they don't. Now, two last ones, the sanctions, or three last ones. The most powerful sanction here is the prohibition on representing the shares at the general meeting. So if I'm under the obligation to make a mandatory bid rule, I have reached 40%, I do not come forward with this bid, well, then I'm not allowed to exercise any voting rights. I'm not allowed to exercise the rights of my shares at the general meeting during this period of time until I make a bid. Then the FSA may also issue an order to effect rectification, but that's just a sanction of a different kind. Next, please. Finally, grandfathering. Well, first point, a party who held shares representing 30% of the voting rights already when the mandatory bid was introduced, the present one in July 2006, may acquire additional shares, of course. It doesn't affect, take a well-known company like H&M, the textile manufacturer, clothing company. The family there held already at that time well above 30%, and hence may acquire additional shares, and they do constantly. I think they now hold 80%. This follows already from the wording in the rule. You don't even need to have a specific grandfathering clause here. Second, and also very important, a party who held shares representing 30% of the voting rights already when the company was first listed may also acquire additional shares. Think about it. We introduce, I'm the founder of a company, well, and the company has grown and it's introduced on the stock market today. Well, then it becomes listed, and the rule applies to a listed company. Hence, the rule applies from tomorrow, so to say, or from today. At that moment, I'm not in a situation where I hold less than 30%. So if I introduce the company today at the stock market, I am holding 40%, I could stay there or I could increase my stake anytime I like. If I go down to less than 30%, well then start buying again, then the mandatory bid rule would be triggered. And the very last slide says, well, this panel, because I think we might touch upon the panel system as well, we are available every day of the week for consultations and also for formal cases. It's not unusual that legal advisors call us on the weekends, or even come forward with a petition for certain interpretation or exemption during the weekends. In cases dealt with by the chair, which is typically some of the easy cases on exemptions, the panel generally announces its decision no later than the day after the final petition is submitted. Other cases, typically, well, it varies from 1 day to 1 or 2 weeks, maybe at the most. So it's a very speedy process at the panel. And the panel is composed of, in total, 30 specialists in this field, but each case is dealt with a panel of in between 4 and 8 members of the panel. So, thank you so much for giving me this opportunity to introduce the system, and now I look forward to any questions or discussions. Thank you.
Okay, thank you very much, Mr. Skog, for thoroughly explaining the mandatory bid rule and sharing your insights from your home country. Now, to talk about the implications of the mandatory bid rule in the case of Korea, we have 4 experts, and we will engage in a discussion with Mr. Skog. I would like to introduce the panelists at this point, which are in alphabetical order of their name. We first have Professor Jun-hyuk Jung, who is a professor of law at Seoul National University. We also have Professor Woo-chan Kim, professor of finance at Korea University, and also the executive director of AICG. We have Professor Woo-jin Kim, who is a professor of finance at Seoul National University, and Mr. Yoo-cheol Im, who is the managing partner of H&Q Korea. The format of the discussion will be as follows. Each panelist will ask a question to Mr. Skog, and Mr. Skog will answer to the question. And then the next panel will ask a question, and Mr. Skog will answer. So we'll have this, and within the time that we have left, I think we have about 15 minutes left. So we'll aim to go through about 2 or 3 rounds of the questions in this way, and hope we get a dynamic exchange of ideas. Okay, with that, let's begin our panel discussion. I'd like to invite our first panelist, Professor Jun-hyuk Jung, to pose his question to Professor Skog.
Yeah, thank you so much, Professor Skog. Good to see you again. Yeah, it was a very insightful and very exciting presentation. So just to give you a very short overview of what's happening in Korea is that we don't have mandatory takeover bid rule. So the controllers are free to sell their controlling stocks without having the remaining minority to give the opportunity to sell their shares. So that's the situation in Korea. So we are basically market rule as opposed to equal opportunity rules. And the discussions that we are having is that the control premium in M&A transaction is very high, and usually the controllers can control the company with only like 30%, 40% of shares in listed shares. So nowadays we are talking about whether we can adopt the mandatory takeover bid rule in Korea as well, because, of course, there are minority shareholders who think that it is maybe unfair for the controlling shareholders to just have the opportunity to sell their shares and receive control premiums, and also sometimes to prevent looters to acquire the company. So those are the discussions that we are now having in Korea. So related to that, I have a question about a chilling effect of mandatory takeover bid rule, which is well known. And because, as you know, the mandatory bid rule originated from the UK, where dispersed ownership is prevalent. But as you talk in Sweden, control ownership is prevalent in Sweden. So the situation is a little bit different from what you have in UK. And for Korea, I think it's more like Sweden. So we have controlling families in listed companies. And the opponents of mandatory takeover bid rule in Korea are saying that if you have the mandatory takeover bid rule, and if you share the same price in M&A transaction, then the burden of the acquirer would be quite huge, and also given the high level of control premium in Korea. So it'll have a very strong chilling effect in Korean M&A transaction. So I hope to know your view about that, given the similarity of ownership structure with Sweden and Korea. Thank you.
Well, thank you so much. Good to see you again. Yes, the ownership structure is different in Sweden, and I can tell you that we hesitated or waited, as you heard, quite a number of years before we introduced the mandatory bid rule in Sweden, and that was to a certain extent, maybe the major reason was that we considered the ownership structure to be quite different, and we were very well aware that this started in the UK in a widespread ownership structure system, with also I spoke to Professor Paul Davis just the other day in London about it, in a time when the minority protection system in the UK Companies Act was not very strong. So that was a need to do something, to have a kind of minority protection system ex ante, and they introduced a mandatory bid rule. And we hesitated in Sweden and said, listen, it's different in continental Europe, typically. In Sweden, certainly, the ownership structure is different, and we do have, we think at least, quite a well-developed minority protection system in the Companies Act. So why should we have this? Well, I have admitted earlier on, and I will do it today as well, that I don't think when this idea came up finally in 1999. Well, first of all, we saw in Europe a movement in the direction of introducing mandatory bid regimes in different jurisdictions, and they were kind of converting towards the UK. So we were beginning to feel, or maybe Swedish industry was beginning to feel a bit kind of, well, run the risk of being isolated. That's in that direction, at least. Maybe there's some of the leading families in Sweden also felt that with a mandatory bid regime, it will be more difficult for newcomers in the market, so to say, for active investors, etc., to take a position in a listed company and challenging the present ownership structure, so to say. I'm not saying that was the reason, but I can't escape the thought that it might have been like that. And again, it was introduced in the self-regulatory system, which, of course, at that time was kind of dominated by large Swedish investors, so to say. And at that time, the institutional investors were not very active in Sweden in this field. So and also notably that we introduced, when we started out at 40%, and that was maybe also a reflection of the ownership structure, and there was a fear, and I was one of them in explaining that there is a risk that we chill down the restructuring of Swedish industry that goes on by doing transactions with block transactions in the market. However, it was introduced, and later on, just a couple of years later, the same representatives in the self-regulatory system said, no, we have to converge to UK. It has to be 30%. And from that moment on, there is not much debate on this. And has it had a chilling effect? Well, that's difficult to say. We have seen in some companies that large shareholders has taken a 29% position, so to say, and they stay there. But the chilling effect, it's hard to say, but I perfectly understand the argument. I'm saying, yes. There are no discussions today on amending the mandatory bid regime in Sweden in one way or another. No. No. Yeah, thank you.
Thank you. Okay, thank you. The next discussant will be Professor Woo-Chan Kim.
Yes, I have a question, actually a clarifying question about lowballing. I just want to understand how it really works. So I recall, I think what you have said is the acquirer makes an acquisition just below the 30% triggering level, wait for at least 6 months, and if the share price is much lower than what you have offered to the original block holder, then even if it is under the, so after the share price has gone down, you make a voluntary full takeover offer. In that way, you don't have to be subject to the mandatory bid rule. So my first question is whether this is what you have mentioned about lowballing. And a related question is, you also said that this lowballing is not common in Sweden, but at the same time, you mentioned that there are very few real mandatory bids in Sweden. And I just want to know why there are not many real mandatory bids, so if this is not the reason. So that's my question.
Okay, thank you, Wolfgang. Yes, the rule is such that if you hold 29% today, and you see the market is going down, you wait for a specific time when you think this is a good price, or rather this is a low price for the shares, and you decide that I want to be able to increase my stake in the future. Well, then you can either buy enough shares, so just buy 2 more percentage points. You are at 31. You have to make a mandatory bid, and then the lowest price in this bid will be just what you paid for that transaction, which could be a very low price. You make an offer, and no one almost will accept, and then you're free to increase since you have made a bid for all the remaining shares. You could also do it like this. You are at 29, and you already from the beginning make a voluntary bid for the remaining shares, and you end up at that low price. You end up at maybe 33 or something like that, and then you're free. So there's just 2 different ways to kind of circumvent the system, so to say. Well, we've seen a couple of cases. We saw one maybe already 20 years ago, and we actually the panel said in a statement that this might be something for the regulator to take a look at in the future, but there was not much interest. Then we have seen a couple of cases during the last year or maybe 2 years, which might create bit of larger interest. And since this is also, as you very well know, internationally debated now, the mood might be different today for this. What do I mean when I say no real mandatory bids? Well, we see extremely few situations where someone kind of almost by accident reaches 30% or more and is forced to make a bid for the remaining shares. Why should you? I mean, if you're a large investor, you have a stake like roughly 30%, then you are well aware of the regulation, and if it's possible that you might end up in having to make a mandatory bid already from the very beginning, you prepare for a voluntary bid for the remaining shares, because then you could introduce all the different conditions that you can have in a voluntary bid, but you can't have in a mandatory bid. So suppose I'm considering increasing, suppose I have 10% in a listed company, and I'm considering increasing my stake, and I'm actually prepared to buy all the shares. There is no idea for me to buy shares in the market or in a block transaction, ending up in 40% and then have to make a bid mandatory, because then I better start preparing for a voluntary bid already from the very beginning, and I can have acceptance conditions and whatever I want to have there. So that's what I mean with no very, very few real mandatory bids. What we see are some of them lowballing, yes, but not very many.
Can I make a short related question? So let's say that there's a controlling shareholder who's holding 40% and would like to sell it to the offerer, and the offerer purchase it with a control premium, then that would trigger the mandatory bid rule. Yes. Am I correct? But that does not happen a lot in Sweden. Is that what you're saying?
It is not common at all, no. In such a situation, you would typically negotiate with the potential acquirer, and if this acquirer is, since she, whatever, knows that I will have to make a mandatory bid, much better than to make a full bid for all the shares, including the 40% stake. So you negotiate. That's what typically happens in a concentrated ownership structure. You negotiate the bid or the potential bid with the largest shareholder. You agree upon what is an acceptable price for you to sell your shares in the bid, and then you announce a full bid, including those shares. And you might have already a commitment from this shareholder to accept the bid, which you announce at the very moment you announce the bid. Yes, that we see a lot. Well, I mean, it's not uncommon at all that already when the bid is announced, the voluntary bid is announced, it is announced that, and we also already have commitments from one or two large shareholders to accept the bid.
Thank you.
Thank you. Next turn, Professor Woo-Jin Kim.
Thank you very much for your presentation. So let me be a little bit more specific about the Korean situation. So the proposal being made right now has the triggering point to be like, if you want to buy more than 25% of the target company, you are required to buy up to 50% plus one share. So we have a different triggering point and then the requirement, right? So I guess goes back to Professor Jung's point. Some of the potential acquirers are worried that if you are required to buy up to full 100%, that may be too costly. So how would you evaluate this type of arrangement? Because we will still have some minority shareholders being left, especially when the bid price is high compared to the current market price. Everyone would want to potentially sell their shares, but they're not able to. It's going to be rationed on a pro rata basis, and we'll still have some minority shares being left. So how would you evaluate this type of framework? And there's one other suggestion where, okay, you are required to buy up to 100%, but allow them to pay a different price. Lower price than for the controlling. It's actually from Professor Chang's idea, and then so there's an alternative ideas. So actually, there's like two. How would you evaluate this one as well?
Well, that's an interesting. If I understand it correctly, if you are taking a stake, if you're taking a 26% stake.
Yes.
You can't stop at 26. You have to make a bid for 50.
Yes. Yes.
It is in a way similar to what you see in the UK, I think, where you cannot make, well, you can make a voluntary bid. No matter what you intend to end up, you can make a voluntary bid. If you make it for all the shares in the company, you may not stop below 50. And it gives a kind of certain guarantee, so to say, that, well, if 50% plus one has accepted, the price must be at least fair. It can't be that 50% are so stupid they accept a way too low price in this bid. So in that respect, it makes sense. On the other hand, if 25% is kind of the mandatory bid threshold here, and you say we have to protect the minority, and we do this by requiring anyone reaching 25% to make a bid, but only for 50 plus one, it sounds like just going half the way, so to say, and you leave a number of shareholders potentially with shareholdings that they would like to get rid of in light of the fact that there is a new controlling shareholder, so to say. Well, maybe I'm missing something here. It sounds a bit odd, and if I might add, I would say, having kind of lived with this regulation now for 30 decades. I also negotiated the European Takeover Directive for many years in the late 90s and early 2000 here. I sense that there is a convergence towards the UK model, so to say, and I think it has some merits. This convergence, it's a bit being a kind of outlier here. There are a couple of jurisdictions in Europe as well that have a more complicated rule, so to say, and of course it might be considered to be this is the right one for our specific situation in our specific jurisdiction, but you have to live with the kind of burden to explain how come you have a different system, and this is why don't you have the more common system with just one level for triggering the bid, and then you have to make a bid for the rest of the shares. It's an easier, but I'm not saying that's a good way to argue against the proposal that you present to me.
Just sure clarifying. Are you aware of any other jurisdiction that has something similar to Korean proposal?
I'm not aware of a jurisdiction saying we have a mandatory bid triggering point, 25 or 30, it doesn't matter.
Right.
And then you have to make a bid for just 50%, so to say, up to 50%. I'm not aware, but there might be, I'm a bit unsure. There might be one or two of especially the more, if I may say so, new jurisdictions or new member states in the European Union that I'm not familiar with. But among the so to say, old ones, the old member states, I'm not aware of anything like that. No.
Thank you.
Okay, thank you. Next panelist will be Mr. Yucher Im.
Well, thank you, Professor Skog, for your insight. Actually, the question was just related to the second question, which Professor Ujin Kim asked.
He didn't answer,
like,
so you can ask.
I would like to elaborate on that in a more practical matter. Is that I think the mandatory bid rule, the purpose of and the philosophy behind that is to protect the minority shareholders. Now, meaning that if this mandatory bid rule, which is related with the chilling effect as well, is basically if there's a price differentiation, then an acquirer are willing to buy the larger stake with a control premium and offer a lower price, for instance, higher than the market price, but something lower than the control premium he's paying. And the remaining minority shareholders would rather exit all their shares rather than not having a bid itself, and because of chilling effect, having no M&A activities. Because there were certain cases in Korea, practically as a private equity fund manager, there are cases that minority shareholders would rather have them shares sold lower than the controlling premium, but like to exit all these shares at a certain price level where they can accept. So I think this is more practical and a way really taking care of the minority shareholders in order for the exit and a certain profit they can take. And I don't know what your thoughts on that, of the price differentiation.
If I understand you correctly, your question is, or your comment is rather that, well, the minority shareholders might find it reasonable to accept that the controlling stakeholder has been giving a certain premium, but as long as we are allowed to sell our shares a little bit above market price, maybe, well, that's fine with us. And there is also, when you think about the rationale for the mandatory bid rule, the major rationale, and that's where it started, is, of course, as you say, and as I touched upon, to protect the minority shareholders by allowing them to get out of the company once there is a new controlling shareholder. But there is also another strand, as you are probably very well aware of, and that is we have the right to share the control premium. The control premium kind of belongs to the company, and hence we should all divide it. I'm not very much in favor of that. I've never really understood that argument, I must say. But that's just one comment. Another one is, of course, that when you look at the debates that kind of triggered the request for a mandatory bid rule in London, in other jurisdictions, and also in Sweden, it has been a debate about how come that the controlling shareholder was allowed to sell those shares at a certain high price with this high premium, and we are left behind. Now we want to get out, but it's not fair that this controlling shareholder received that high premium. We are not. So that's another. And I can tell you this, and in Sweden we have, as I mentioned, the system with multiple vote shares. We have the high vote shares and low vote shares. Very common, very common. Roughly 50% of the listed companies have this system. And let's not think about a mandatory bid for a moment, just voluntary bids. We experienced, of course, over the years that the high vote shareholders were offered a high premium for the high vote shares from a potential bidder or from a bidder. And then the low vote shareholders were offered a different, lower price. The institutional investors in Sweden, that they all accept this system with high vote and low vote shares. They think it's good for corporate governance matters. But when it comes to bids, voluntary bids, they started to argue, no, we can't accept whatever difference is here. You can't pay 25% more per share for the high vote shares than for the low vote shares. So the institutional investors started to argue in favor of lowering this difference, and they succeeded. In 2012, they succeeded demanding that in a voluntary as well as a mandatory bid situation, the price must be equal for high vote shares and low vote shares. And that's a sign that the tolerance, so to say, among minority shareholders, especially institutional investors, for accepting someone receiving a premium for a controlling stake or high vote shares is no longer there in Sweden. And I myself find it a bit strange, and we are in Sweden is so far the only jurisdiction that I'm aware of having such a rule: equal price, no matter in the bid, no matter what kind of shares you're buying there, so to say. In Switzerland, as I think they accept a 20% difference between in a voluntary bid for high vote shares compared to low vote shares, but that's my recollection only. Well, I don't know if that was an answer to your question, but it was absolutely three comments, so to say, at least.
Oh, thank you. It was very helpful.
Thank you. I think we have time for one more round of panel discussion. So we're back to Professor Junhyuk Jung for his second question.
Yeah, so thank you so much once again answering all the tough questions. It's really appreciated. So my second question would be a little bit easier than previous questions. So, so I understand that you have the panel, and I think that the tradition of panel comes from UK, where they used to have the city code and the panel, which is not a government authority. But I think the situation in Korea is also similar to Sweden in that if we adopt mandatory takeover bid rule, it will be in our law, and basically it's our financial authority who will be supervising the procedure in mandatory takeover bid. So my question is that since you have a panel, it's not your financial authority who are dealing and deciding with the exception. So what are the advantages of having a panel instead of a financial authority to deal with these cases?
Well, thank you. When we amended the Swedish regulation to fit with the takeover directive, we had to introduce, as in the UK, a legal basis for the system that we already had in place. There's the self-regulatory system, and we asked the investors, the market in broad terms, and the advisors, etc. What do you think are the merits of the current system, or should we go for the FSA solution instead, as most jurisdiction in Europe, continental Europe, do? And the answer was no, you should not. What is important here is speed and the possibility to get speedily interpretations and exemptions in advance, especially interpretations, I would say. Well, of course, exemptions as well. But so typically for a voluntary bid, it can be a very typical situation is one of the leading legal advisors comes to the panel and say, we are considering setting up a consortium with a private equity company to make a buyout of a listed company. Would you find the following conditions for this consortium to be acceptable in your view and your interpretation of the equal treatment principle, etc., in the law. And they will have an answer within a couple of days from us. If you compare that to an FSA, well, we asked the FSA when we set up this system in 2006. We asked the FSA, they participated, of course, in the legislative discussions, and they said, well, for us, it would be at least a month, maybe 3 months. And the advisors and the investors said, well, that's not acceptable. We can't have a system like that, you know. And speed is when it comes to the handling of the individual cases, but also the composition of the group deciding here. The panel is composed by the most experienced legal advisors from different law firms, from banks, also from former CEOs of listed companies, could be people from the private equity industry, etc. It was a very, very well, the top guys, so to say, in the community in Sweden. And this you don't have at the FSA, at least not in Sweden, I'm sorry to say, and they admit it. So the result was that the FSA decided with the foundation in the law to delegate this power to the panel and say, you can do it. And if you're not satisfied with the decision by the panel, you can appeal to the FSA and then to the administrative court. That has happened when it comes to exemptions from bid 4 times over 25 years, non-successful. I think 2 were withdrawn. And of course, I mean, an administrative court, what do they know, to be honest, about takeovers? Nothing.
So which means that you did a great job during the last 25 years.
Well, we do our best.
Thank you.
Okay, thank you. Professor Woo-chan Kim, would you like to ask a second question?
Sure. My question is related to your answer to my first question. So you mentioned that if there's a controlling shareholder holding 40% of the shares, and if there's an acquirer who wants to take over the company, there will be a pre-arrangement, there will be a negotiation over the price that the acquirer will offer when it makes a full takeover bid. And then after making a bid, the controlling shareholder would also sell their shares, block of shares, at that price, which will be same as the price offered to all the remaining shares. So my question is, this offering price, would that be lower on average to the price that used to be used to acquire or 40% of a stake before the mandatory bid rule regime in Sweden? I think you can answer this because you have more than 3 decades of an experience in Sweden.
Yeah, I still can't answer. I must admit, we have no statistics on that. And it would be interesting to try to find out. There are no figures, I'm sorry, and no statistics. The hard thing here would, of course, be to find out the block transaction price before we introduce the system. I'm not sure how to go about to do it from an academic perspective, but no, we don't have the statistics. We don't know. But I fully understand your question here. I would say maybe, correct me if I'm wrong, there is no reason for, if you start, which is typically the case, suppose I want to buy, or someone wants to buy Electrolux. They have to negotiate with the Wallenberg family for the controlling shares. And the negotiation ends up with, well, we would like to have here, or our demand is 500 per share, so to say. Well, if then the bidder has to, potential bidder has to ask himself, am I willing to buy all the shares at 500? If not, there will be no bid. So I don't see why the controlling family would lower their price, so to say, for the shares, just due to the fact that the bidder has to make, or the buyer has to make a bid for all the shares. It would rather end up with no bid. Or could very well be the case. But still, we see no decrease in takeover activity in Sweden. No, rather the opposite. Yeah.
Okay, thank you.
Thank you. Next panelist, Professor Woo-Jin Kim, for your second question.
Yes, so I've noticed that you spent a considerable amount of slides on exemptions explaining. So to me, it sounds like out of all takeovers that are originally subject to this rule, many of them are exempt. So my first question is, so what's the percentage of takeovers that are subject to this rule, but that are ultimately exempt? What's the percentage? That's my first question. And I was very much intrigued by the typical reasons for the exception. And one of out of them, you mentioned the target being in distress. Because in Korea, many of these block transactions, especially the large ones, the targets are in distress. And the typical example is the second largest aircraft carrier, carrier in Korea, Asiana, is being taken over by Korean Air, the largest airline. And then if Asiana is in distress, according to Swedish regulation, then they'd be exempt from this mandatory takeover. Right? So then my concern is that because many of these large targets are in distress in Korea, even if we actually adopt Swedish regulation, then many of them will be exempt because they're in distress.
That could be the case, but in such a situation, we would suppose then the company wants to make a targeted share issue to a specific investor, taking 50%. Yeah, and we would look at the total situation in the company and try to come to a conclusion on what is best for the shareholders here. Either the company goes bankrupt, possibly, or we give an exemption, and this potential investor has the possibility, hopefully, to save this company if that's what we want. If we allow this targeted share issue to go through, and we allow this investor to take a 50% stake, that could save the company or rescue the company for the future. And if we come to the conclusion, well, that is probably best for the investors or for the shareholders in the company, then we would give an exemption, and this investor can stay at 50%. There will be no bid. If the investor wants to make a full bid for the remaining shares, that's fine as well. But the typical exemption situation for rescue situations is that the company wants to find a specific investor taking a certain position above 30%, but not make a bid for all the shares. That you can do, of course, but that's a different story. The thing is, can we allow a new investor coming in, taking a large stake above the 30% level? But I must say that over the years, if I look at all the exemptions, I would say that out of maybe 500 exemptions, my guess, I wouldn't say that more than 10, 20 of them are rescue situations. We see very little of that.
Out of all takeovers that are subject to, how many of them are exempt? What percentage?
Well, I'm not so sure that one can look upon it. That what you can look upon is saying, well, how many exemptions do you give typically during a year? But if you had not given them the exemption, would they have made a takeover bid? No, in very few cases, because again, they come to the panel on beforehand and they ask, what about if I participate in a preemptive right issuance of new shares? Or what about if I sell my company to this listed company and becomes a large shareholder in the listed company? Would I get an exemption? Could you give me an exemption? And if the answer from our side is no, for one reason or another, you will not get this exemption, it won't end up typically in a takeover bid. Rather, there is nothing is done, so to say. There will be some other transactions, but there were. So it's hard to compare the number of exemptions to a potential total number of takeover bids. It's not a kind of totally irrelevant comparison, I think. You can compare. You might say, well, if you look at this year, as I said, roughly 40 takeover bids. No exemptions, no nothing. They're just voluntary, or some of them, a number of them, also mandatory bids. That's the number of bids. And the number of exemptions this year, again, maybe 30, 40, something like that. But again, that's typically for situations, if they had not been given exemption, we wouldn't have seen a takeover bid.
Okay, thank you.
Okay, thank you. Okay, last, Mr. Yucher Im, you have the honor of asking the concluding question for today's session.
Again, it's more of a practical question. Actually, it's not about protecting the minority shareholders, but as a controlling shareholder and a potential dispute trying to control over the company. For instance, you are 40% the largest shareholder in the company, and because the MBR says that it only appears that there's a change of control. So technically, if somebody achieves up to like 37%, and the second largest shareholder doesn't apply the MBR rule, and then there's no acting in concert proof. There's no shareholder agreement with other parties, but at a shareholders meeting, there could be some kind of a fight over the control, and the 40% largest shareholder will feel unfair because he or she can acquire more shares in the market because of MBR. So I don't know whether, that kind of case could occur, but right now in Korea, it's not about the mandatory bid rule, but there are such issues about typical block of shareholders acting in concert, but not having a shareholder agreement and trying to have dispute of the largest shareholder.
Well, I'm not sure. I don't fully understand the situation, but there are cases where there are competing blocks of shareholders in Swedish listed companies, for sure. But that does normally has very little to do with acting in concert. If they agree on a common position when it comes to the future of the company, that could trigger a bid. But otherwise, maybe I misunderstood the question.
I'll rephrase it. So basically, you have to be the largest shareholder to be the MBR, but if you're beyond 30% and you're not the largest shareholder, you don't have the MBR mandate to do so. Yes, so in that case, but it could create a lot of problems in the future. So why is it only for achieving the control of the company rather than the number itself or the 30% rule? So why doesn't the second largest shareholder trying to increasing their share doesn't have to do mandatory bid?
Well, it would. So if there is all, then I think I understand it. You have this 40% or 50% shareholder, and someone else exceeds 30%. Shouldn't we? Well, it would be kind of mean if you stick hard to the idea or the rationale that this is triggered when you reach control, you can't possibly say that there are two shareholders holding control of this company. If one is already above holding and holds 40%, it's a bit odd to say, well, then comes in another controlling shareholder. But I mean, it wouldn't be totally impossible, I guess, to say, well, even the number two has to make a mandatory bid here, and let's find out who is the winner, so to say, at the end of the day. I have no strong position on that, but I can tell you the situation as such is complicated in other ways as well, because if you don't, and this is just a comment on it, you allow this 40%, you have this 40%, comes in someone to 33%, you give an exemption and say, no, it's not a de facto change in control. Well, then that position is in the hands of the largest shareholder. Suppose they are pretty close to each other, maybe 35, 34 only, and then the number one, 35, decreases his shareholding a little bit. Suddenly number two is number one, so it's the mandatory bid triggering is in the hands of the largest shareholder there, which could be a problem. And we have had that situation maybe 20 years ago. They were very competitive, these two shareholders, and we saw different tricks. So it's a complicated situation, I admit.
Thank you.
Okay, thank you, Mr. Skog, for sharing your deep expertise and experience in this area. Thank you to all the panelists for bringing the engaging questions. Thank you for everyone in the audience for being part of this session. I think today's session have shed light on the complexities of regulations that try to balance the interests of both the acquirers and the minority shareholders. Hope seminars like this could help improving the corporate governance systems in Korea. So we look forward to welcoming you to our future seminars. Until then, take care. Bye.
Thank you. Bye.
Thank you. Thank you.